and welcome to the Arbitration Conversation. So this is especially exciting. This webisode, we are going to have a discussion with a top scholar in arbitration. In fact, if you think about the Arbitration Conversation and to even have this series, you kind of can't have this series without having a guest, this guest, Stacy Strong. She publishes under SI Strong. She primarily publishes in the areas of international commercial arbitration, international commercial mediation, as well as mass claims dispute resolution, often involving complex matters and multi-parties throughout the world. What we're going to talk about today is especially interesting for a lot of different reasons, and that is trust arbitration, which many people may not have heard a whole lot about. But in essence, you're talking about internal disputes among beneficiaries and/or trustees involving a trust. And Professor Strong, she's also, I didn't even mention, she's a professor at University of Sydney in Australia, and prior to that, she had been my colleague at University of Missouri. So she also edited a book on trust arbitration with Oxford University Press that came out in 2016. So Stacy, welcome. I could go on, there's so much to say. So thank you for being here.
Thank you, Amy. And for those of you who don't know Amy personally or professionally, she, of course, is a rock star herself. She is one of the leading scholars on consumer arbitration, so it is a great honor for me to be here and amongst the colleagues that I've seen already posted on the Arbitration Conversation. So thank you for doing this, Amy.
Well, this is really fun because, first of all, if you could explain for everybody watching, what exactly is trust arbitration?
Okay, so most folks in the United States in particular have not thought about trusts since they were in law school. Maybe they took a class on trust and estates, and they may recall that a trust is, sorry, I'm going to start using my hands because I always talk with my hands. A trust is an instrument that is used to convey or protect property. Basically, there is the settlor, the person who has the money and wants to give it to someone else. And there's the beneficiary, who's the person who receives the beneficial interest. They receive the goodies. And then you have the trustee, who has the exciting job of taking care of the money or property, but receives no benefits. Maybe they get paid a little fee for taking care of the funds. A trust is a common law instrument, but civil law jurisdictions have often used similar formats called Stiftung or foundations or associations to achieve the same kind of purpose because it's a very useful instrument. So trust arbitration involves trust-related disputes, and when we talk about the internal disputes, it's usually between the trustee who has maybe done something wrong and the beneficiaries, or maybe the beneficiaries think that somebody has been wrongfully paid or wrongfully not paid. So we're talking about those sorts of disputes involving typically the trustee and or the beneficiaries.
So how do we end up kind of in this, even talking about arbitration versus litigation with respect to these disputes?
So traditionally trust disputes have been litigated because the court has had an oversight capacity. Trusts are considered special instruments because you have this fiduciary relationships, and so the courts take a very close eye to watch what's going on. And in fact, often have continuing jurisdiction, which is not something that we normally see in litigation. You will have this continuing oversight capacity. As we'll talk about, I think in a minute later, there are some problems with trust litigation. And so now there's been this move towards arbitration for a variety of reasons, including privacy, because trusts are very private instruments, speed, specialized arbitrators, but there's a problem. A trust is not a contract. A trust in the intergenerational sense is donative in nature. You're donating the money. If you think about the typical trust child, you're getting money from your parents. It's a donation. But there are commercial trusts that look more like contracts. And so that could lead to some distinctions in whether arbitration is permitted in one context or another.
Well, and why, especially with arbitration, and as we're talking about litigation versus arbitration in this area, I would imagine that the fact often it's international in scope.
Absolutely. When we talk about the intergenerational trusts, the traditional trusts, again, we think about trust fund babies. We think about placing those trusts in the Cayman Islands, in Bahamas, someplace that is very friendly in terms of the taxation element and in terms of the privacy element. And people these days, maybe not during COVID, but during these days move around a lot. And so you can have, cousin Betty is out living in Timbuktu, and yet she is a beneficiary. And so you have this international element. Commercial trusts are also very, very international. Think about mutual funds, pension funds, et cetera. And so you will have investments in different jurisdictions. And so there can be an international element as well.
That's really interesting. Yeah, because even in your article, I was thinking about why Bahamas, because I noted there was a law in Bahamas, and now that you say this, it makes sense. So what about US law? How do we deal with trust arbitration under US law?
So in the United States, we have struggled with this concept that a trust is not a contract. And arbitration, you need consent, typically in an arbitration agreement or contract, and there can be some slight distinctions between whether something is an agreement or a contract. And I see you nodding as the contract professor. So this concept of can we be in arbitration with a trust dispute really started to take off a decade or so ago, and we saw some legislation and we saw some court cases. In terms of legislation, we have a number of US states that have specifically permitted arbitration of internal trust disputes. There may be some distinction as to which kind of disputes, but if you look at Arizona, Florida, Missouri, New Hampshire, and South Dakota, you will see very clear provisions allowing arbitration of internal trust disputes. The Uniform Trust Code, known as the UTC, also has some provisions, as do Washington and Idaho, but they're a little bit more ambiguous because the problem with trust arbitration has always been, can you put the arbitration provision in the trust itself? Because then the settlor either dies or has no, sorry, I used to teach trust in the States, so I used to kill off people 4 days a week, 14 weeks out of the year. So to me, killing off a settlor is absolutely not a problem. So I apologize if I've offended anyone. But the settlor is out of the picture in one regard or another. And now you just have the trust. So can that bind people who may not yet be born or may not have consented to this arbitration agreement? The UTC and Washington and Idaho are not clear whether an arbitration provision in that trust will bind those other beneficiaries, or whether the trustee, as the legal owner of the property, needs to get a specific contract with those beneficiaries and thereby have explicit consent outside the trust. So there's a variety of types of domestic legislation dealing with this issue, but the majority of states are silent as a matter of legislation.
Well, then what do you do? I mean, I'm thinking now from sort of a practical perspective, sort of what do you suggest in those situations with it being such ambiguous law?
So we will need to get some test cases. Perhaps the best known judicial decision on trust arbitration comes from the Supreme Court of Texas in a case called Raquel and Wright, and I may be mispronouncing those, but it's the Texas Supreme Court. And there, the court relied on a doctrine known as, well, they use the term direct benefits estoppel, but in the trust realm, that's usually called conditional transfer. Basically, it says, if you take a gift under a trust, you have to accept that trust and all the terms and conditions that are included. So if that trust includes a trust provision, you have to arbitrate. If the trust provision says arbitrate, you have to arbitrate if you're going to take a gift. Now, there's some problems with that theory. Basically, if you're saying the trust does not exist or it was invalid for some reason, then that conditional transfer doesn't really apply. But at least there are some cases that have dealt with that issue. California, the Court of Appeal in MacArthur versus MacArthur, as well as Roel versus Ritchie, have dealt with that concept of estoppel, essentially. But we are probably going to need to see some more cases. And for that, we need people to put more trust provisions in their trusts.
Right. Well, it's kind of interesting. I mean, it seems as though it's not even a problem you can clearly draft around.
Yeah, it's something that you need to have a clear arbitration provision. Of course, you always do, but right. you can't escape that problem if you don't have the legal regime behind you.
100%. That makes a lot of sense. Well, what about on the international front? What sort of international law has developed around trust arbitration?
So not surprisingly, because of the common law bent of trusts generally, the common law jurisdictions where trusts are popular have been the leaders. So Guernsey, which is part of the United Kingdom, is a leader, and the Bahamas is a leader. And New Zealand has just recently adopted a new trust act, the Trust Act 2019, and that provision will come into effect on July 30th, 2021. So it's coming up.
Yeah,
and it essentially deals with all the issues that we're talking about. It says explicitly that trust arbitration and mediation are permitted. It will exclude certain types of disputes, like those involving lack of capacity of the settlor. If there's a question about the validity of the trust. It deals with the issues of unborn or unascertained beneficiaries, and I won't go into that, but it is a relatively modern pro-trust arbitration provision. And then there's a number of civil law jurisdictions that also permit trust arbitration, but those again are primarily in the commercial context.
So in reading your article that came out recently in Wolters Kluwer, I guess I'm sort of struck by this overarching question of legislative sort of process, right? And who's all at the table when this sort of legislation is developed. Maybe you could speak a little bit about recommendations, sort of how we do come to the best laws in this area, because you have arbitration on the one hand, you have trust law on the other. How do we make sure that all the right people are at the table?
And this is a really good question, because it goes both to legislation as well as to drafting of arbitral rules. Because both of them are trying to set up a regime that deals with the special nature of trust arbitration. And for that, you must have the arbitration experts, because we know competence. We know what we're doing and how sophisticated and good arbitration can be. And we need to have the trust experts, because they know the special trust-related issues that courts are going to be concerned about. And if those two groups do not talk to each other, you're going to end up with rules that are good on some things and bad on others. So we have some trust institutions that have devised their own specialized arbitration rules, and they do not comply with best practices in arbitration. Similarly, we have some arbitration institutions who have adopted provisions, but they're not really speaking to the trust disputes. So these two communities must get together and they must talk about what's appropriate.
Yeah, because it's such a highly specialized area. You've got to know what you're talking about. I wondered, has there been any movement toward an international treaty or a uniform law or anything on an international scale?
No, I don't believe that the issue is big enough for, certainly, UNCITRAL working group
Right.
it's not big enough to address yet, meaning it's just not popular enough. But the International Chamber of Commerce, through its arbitration arm, has been thinking about these issues. And of course, once the ICC thinks about something, it starts to get some traction. There's also, I've been consulted, and I can't name the entity, but there are some movements afoot to create a specialized trust arbitration institution, and that might come out in the next year or so. So it is becoming more of interest, because trust lawyers are starting to believe that arbitration is a good thing, and arbitration practitioners and scholars, through things like the Arbitration Conversation, are starting to understand that there's a specialized field, and they need to get in and help it develop appropriately.
Yeah, no, thank you. I mean, this has been really interesting, because I agree. I mean, it seems as though it's just an area naturally that would make sense to use arbitration and perhaps mediation as well, because litigation just might not be the best way for these types of disputes, especially given all the reasons that you state. Well, thank you so much for taking the time with us. This is really good stuff, and I hope that it'll be a lot for people to chew on for the rest of their afternoon. So
My pleasure. Thank